If a mentally incapacitated person enters into a contract, a court will follow either the void rule or the voidable rule to determine the contract's validity. Under the void rule, a contract is considered inherently void and therefore has no legal effect. Under the voidable rule, the contract is presumed valid and binding unless disaffirmed by the incapacitated party. In Hernandez v. Banks, a Washington, D.C. court decided whether to join the majority of jurisdictions by adopting the voidable rule. In March 2001, Bryant and Sheillia Banks entered into an agreement to lease a property from Patricia Speleos. That same month, Speleos entered into several other real estate transactions. Prior to the Banks' lease agreement, 718 Associates had purchased a tax sale certificate for the subject property. In August 2001, 718 received a tax deed on that property. In November 2001, as part of a separate proceeding, Speleos was declared mentally incapacitated. Based on her incapacity, the judge voided the March 2001 real estate transactions but didn't rule on the validity of the Banks' lease. In 2003, 718 filed a suit to quiet title. While that suit was pending, Speleos passed away. 718 eventually obtained title to the property. 718 filed a suit against the Bankses, seeking possession of the property. The Bankses claimed they were entitled to remain tenants because they had a valid lease with Speleos. 718 claimed the lease was inherently void because Speleos lacked the mental capacity to assent. The trial court held that although Speleos was mentally incapacitated at the time the agreement was made, this agreement was only voidable, not void. The trial court upheld the agreement because there was no evidence suggesting that Speleos or her representative disaffirmed it. 718 appealed. Amid this appeal, 718 sold the property to Ricardo Hernandez, who was substituted as a party. A 3-judge division of the D.C. Court of Appeals reversed, stating that precedent required it to find the agreement inherently void. The Court of Appeals, sitting en banc, reheard the matter.